Welcome to the Gambone Law Podcast, brought to you by Gambone Law, a Philadelphia-based criminal defense law firm. This weekly podcast is based on questions that we have received from clients and their families. Our law firm is committed to providing the highest level of professional service through aggressive advocacy and serving as a trusted advisor during a tough situation. To learn more about our law firm, read my weekly blog, watch my videos, or download one of my strategy books, visit gambonelaw.com or call 215-755-9000 24 hours a day to schedule an appointment. This podcast is for information purposes only and does not establish an attorney-client relationship. Well, welcome to episode 11 of the Gambone Law Podcast. I can't believe it's episode 11 already, but here we are. Despite the coronavirus, we are here, and I'm here to talk about not a particular topic today. Today, we're going to just discuss some random questions that have come in, questions that our clients and our family have found important, questions that we have received either on the phone or in the office, and I've taken them now, and I'm going to go through them. So question number one. I was charged with simple assault and aggravated assault in Pennsylvania. What is the difference? Can I be found guilty of both? What type of penalty would I face if I was convicted? Well, that's several questions, so let's take them one at a time. So simple assault and aggravated assault. Simple assault would be the misdemeanor charge, and aggravated assault would be the felony charge. Typically, a simple assault is graded as a misdemeanor of the second degree. It can be graded as a misdemeanor of the third degree, but in most situations, it's misdemeanor of a second degree. In some situations, an aggravated assault will be graded as an aggravated assault of the first degree, and in a lot of situations, it's a felony of the second degree. So the major distinction is one is a felony and one is a misdemeanor. With regards to the elements of the offense, the simple assault is a unauthorized touching, basically, with an intent to harm, to cause bodily injury, whereas an aggravated assault is an intent to cause or causing serious bodily injury. So that is the major distinction. One is bodily injury, one is serious bodily injury, or an intent to cause serious bodily injury. And also simple assault, there's an intent element there, so either intent or actually causing. So in these two situations, you can be charged with both. If you were convicted of both of these offenses, they would merge for the purposes of sentencing, but nevertheless, you could be charged and convicted on both. Obviously, if you're convicted of a felony offense, you face a much more of substantial penalty as opposed to a misdemeanor. Neither of these charges can be expunged or sealed, but obviously the felony is much more severe. So if you have no prior criminal history, and I'm not sure if this person does, could they go to jail? It's a possibility, depending on the gradation of the felony charge. The felony of the first degree obviously carries with it a higher offense gravity score than the felony of the second degree. The misdemeanor offense of simple assault, could you face jail time? Again, you could. It's a misdemeanor of the second degree in most situations. The maximum penalty is 2 years of state incarceration, whereas the felony charge is much more of a substantial state prison sentence. So it's a maximum of 20 years for a felony of the first degree. Felony of the second degree, it's a maximum of 10 years of incarceration. In Pennsylvania, an ungraded felony or a felony of the third degree would be 7 years of state incarceration. Now, more than likely, a person would never face the maximum punishment, but again, those are the statutory maximums. So again, prison really, it depends. Depends on prior criminal history. It also depends on what evidence comes out either during a plea or during a trial. I would think that if you enter into a negotiated guilty plea, prison or jail would be unlikely, but again, it depends on the situation. All right, next question. I want to buy a gun, but I'm not sure if something in my past makes me ineligible. I don't think it's a felony. It could maybe be a misdemeanor. Would that make me ineligible? Well, a felony offense under Section 6105 would make you ineligible to possess or buy or purchase a firearm in Pennsylvania or New Jersey. The law is very clear on that. But there are other offenses which could make you ineligible to purchase a firearm. For instance, if you have 3 DUIs within 5 years, that could make you that will make you ineligible to possess or buy a firearm. Also, if you have an active protection from abuse order, which we discussed during one of my previous podcasts, that again would make you ineligible. It's also important to understand that when you buy a gun in Pennsylvania, you have to fill out an application. And in that application, it'll ask you a series of questions. You never want to assume that you have the answers to that question. If you believe you have something in your past that could cause you an issue, you want to speak to an attorney about it, or at least speak to someone regarding running your background to make sure nothing is in there that could cause you an issue. It is a crime to make a false application in Pennsylvania. It can be graded as a felony and or a misdemeanor offense in some cases. Making a false application can be graded as a felony of the 3rd degree, which is obviously very serious. Typically, what we see in our office when a person makes a gun application, they fail to understand the question. The question will ask, I believe it's question 33 on the application, if you've ever been convicted of a crime where the maximum penalty under the law exceeds 2 years. So people don't understand the question. You may have received a sentence. Where the punishment was, say, probation, but the maximum penalty under the law exceeded 2 years. What I'm talking about is a misdemeanor of the 1st degree. So you may have a conviction for a misdemeanor of the 1st degree, for instance, some simple assaults, I believe, possession of instrument of crime is a misdemeanor of the 1st degree, terroristic threats, I believe, is a misdemeanor of the 1st degree, and even recklessly endangering another person, I believe, is a misdemeanor of the 1st degree. That one might be a second, but I believe it's a first. So in those situations, you would have to respond yes to that question. If you responded no, that would be wrong. And again, the law doesn't use I didn't know as a defense, so you can't assert that. Now, obviously, you can use it for the purposes of mitigation, and possibly the failure to understand the question could be used by your attorney during a possible plea negotiation, but your lawyer could not use it as a defense, and it's important to keep in mind. Never make an assumption. So in this situation, you may believe that you don't have a felony, but I've spoken to a lot of individuals who think that they don't have felonies. They say, oh, I just pled guilty to pushing a police officer or something like that. And you have to understand, going back to the first question, that simple assault is normally defined as bodily injury, whereas aggravated assault is serious bodily injury. But in the case of a person of a protected class, for example, police officers, firefighters, EMS, I believe even public school teachers, if you cause bodily injury to one of those individuals, that is considered an aggravated assault, graded as the felony of the 2nd degree, I believe. So again, sometimes I talk to people who are not even aware of what they actually pled guilty to because they weren't listening to what their attorney was telling them during negotiations, or all they heard was you'll get probation. And probation is not only not a free ride. Again, you can have a situation where you could receive probation, but that conviction will follow you for life. And I've said this before, you want to look at the gradation. And in some cases, I would advise clients to take more probation in exchange for a misdemeanor conviction as opposed to a felony, or even accept things like house arrest in exchange for the downgrading of a charge from a felony to a misdemeanor, if that's possible. Because the felony charge can never be removed, and it will cause serious problems down the road. So you never want to just assume that what you pled guilty to was not that serious simply because you didn't go to jail. Okay, what is the difference between a limited access petition and an expungement? Well, in Pennsylvania, this is fairly new. You have the ability to file a limited access petition for crimes in which you were convicted of. Typically, these are ungraded misdemeanor offenses. Things that would not qualify would be things like simple assault, terroristic threats. Things that would qualify would be things like convictions for DUI and simple drug possession, not possession with intent to deliver, which is the ungraded felony charge. So the limited access petition can be filed 10 years after the conviction, assuming that you've had no other convictions since that time. Again, it doesn't have to be granted, but in most situations, it will be provided that you've met those conditions. It's also important to understand that if you're filing these petitions, prior to filing them, you want to make sure that all your fines and court costs have been paid. Even though the court may have stopped sending you letters or didn't send you any letters, if a balance exists, the court will not grant any type of limited access petition. With regards to expungements, those are situations where you've not been convicted and your record can be completely cleaned. Limited access, just as the name implies, only certain individuals or organizations can view your record, typically law enforcement or government agencies or certain licensing agencies where you're going to have contact with people. For instance, if you were applying for a law license or a medical license, I believe that the State Bar Association or State Bar Examiners and the medical licensing boards could probably gain access to those type of records, or if just flat out ask you on the application if you've ever been convicted of a crime, including ones that have been expunged or sealed. And that's an important point. Obviously, you can file for a limited access petition or an expungement, but if the question on the application asks, "Have you ever been convicted?" you have to answer the question yes if the question is qualified with including expungements and sealing of records. Again, it's there. It's a question which could be considered part of your employment contract. If you're dishonest, your employer would have every right to terminate you or void the contract. I'm not an employment lawyer, but again, some people would tell you that it's a judgment call. I disagree. If the question is asking specifically about an expungement or sealing records, I always advise to be upfront about it and better to deal with it head on in most situations. If it is something in which you are permitted to file a petition or get an expungement, it's really not that serious. And I don't believe that one conviction that was later expunged for a possession charge or a DUI would necessarily prevent you from obtaining employment, especially if it's a long time ago. So again, I think that's important to put out there. All right. Next question. I've heard that Pennsylvania doesn't have any mandatory minimum sentencing for crimes. Is that true? Well, it's not true. Pennsylvania, unlike New Jersey, doesn't have as many. New Jersey, for instance, has mandatory minimum sentencing for most of its gun crimes. Pennsylvania doesn't have mandatory minimum sentencing for firearm and gun charges, but there are situations where that is not the case. So two common examples of mandatory minimum sentencing is the possession of contraband within a state or local county jail or prison. In this situation, if a person is found to be in possession of a drug, of a controlled substance, a narcotic, they can be charged with a felony of the third degree, and the mandatory minimum sentence would be 2 years of state incarceration. Now, there are situations where the district attorney's office can demandatorize that, but again, it's a case-by-case basis. But basically, in that type of charge, what the Commonwealth has to prove is that you had possession of the item and have to show that you brought it in, not just, again, giving it And they don't have to find you guilty of actually giving it to somebody, but simply putting it in a position where you could give it to somebody. So examples would be that you brought it in the facility and it was in your pocket, and they found it during a search. You have to understand that you don't have a constitutional right against the illegal search and seizure. By entering the facility, you give up all those constitutional rights. Now, once we get into whether or not they can establish whether or not you wanted to give it to someone in there, that's where we go into trial issues and whether or not they can establish their burden. But in terms of just initially charging you, I believe that if they just find it on you, you're going to be charged with that crime. Now, whether or not it can be proven at trial beyond a reasonable doubt is a different story. That's where you and your lawyer should get into the elements and really what evidence they have. Do they have cameras? Do they have video? Do they have pictures? What potential witnesses do they have? Where were the drugs found? Things of that nature. Who are you there to see? Those are all important issues. The second mandatory minimum that we frequently see is the straw purchases of guns. So normally, if you buy a gun, obviously it has to be for your use. And there are situations, however, where people buy guns for other people. Now, there are exceptions like buying guns for purposes of gifts, which is what I'm not talking about. But in situations where you're buying a gun with the purpose of giving it to somebody who's otherwise ineligible, that is a felony offense where you could be charged. And if you were charged, if it was a second offense, and again, offense is defined as per gun. So if you're in a situation where you're buying several guns, the first gun would not subject you to the mandatory minimum sentence, but the second gun would, and it's mandatory minimum 5 years. Pennsylvania just began implementing this a few years ago. It is known as the Bradley-Fox law, I believe, named after a police officer, unfortunately, who was killed in the line of duty by a weapon which was the result of a straw purchase. Okay. If I'm arrested for DUI, do I need to take a field sobriety test? What happens if I don't take the test? Well, the answer is no. You don't need to take a field sobriety test. Field sobriety test and chemical test are two different things. Field sobriety test is, some examples are the horizontal gaze and nystagmus test, the walk and turn, the one-leg stand test. Chemical testing would be a blood test or a breathalyzer. Chemical testing is required, even though you can't be charged criminally with refusing a blood test. You can be charged criminally with refusing a breathalyzer, a blood test. We talked about that in a previous podcast. The police need a search warrant to take your blood. But that being said, you should never refuse either a blood or breathalyzer test. If you refuse those tests, PennDOT administratively can suspend your license for 1 year, regardless of what happens in the criminal courts. So that's important to keep in mind. You never want to refuse a test. If you do refuse a test, there are things that we can do on the civil side to potentially call into question whether or not it was a voluntary refusal, but that's an uphill battle, and you have to understand that the civil standard is much less than the criminal standard. Don't forget that in criminal court, the burden of proof is guilt beyond a reasonable doubt, whereas in the civil world, it is preponderance, so more probable than not, which side is more believable, if you will. Whereas in the criminal courtroom, it's guilt beyond a reasonable doubt. It is the highest standard. So the fact that you're found guilty or not guilty in a criminal courtroom does not necessarily mean that you will have the same result in a civil action. So with regard to field sobriety test, if you don't take it, what happens? Well, they're obviously going to argue that you didn't take it because consciousness of guilt is the term that they will use, that you knew you were guilty and that you didn't take the test. Now, it's on your attorney to argue to the court why you didn't take the test. Now, what I would tell you is that if you're not taking the test, you want to tell the officer why. You want to say that I have a physical illness or I have a condition which prevents me from doing these tests, whether it be arthritis or some type of issue with your legs or your arms. Obviously, you have a driver's license, so it would have to, that would have to be explained as well. But again, I would put it out there if you're unable to take the test, knowing that you aren't going to probably pass it. There's nothing wrong with putting that out there. If the officer wants to tell the assistant district attorney that he or she was not taking the test, and again, in his opinion, he was intoxicated, well, that's fine. Let them do that. It's up to your lawyer to argue the opposite and say that you didn't take the test for several reasons. And again, case by case basis. But I would not take the test if you're going to fail because of some physical issue. And again, if you don't take the test, it will not result in a license suspension, unlike the chemical test. Okay, I was told that Pennsylvania and New Jersey will suspend your driver's license if you are convicted of any drug offense. Is that true, and is it mandatory? Well, in Pennsylvania, that used to be the case. If you were convicted of any drug offense, whether it be possession or the felony offense of possession intent to deliver, your license would be suspended for a period of 6 months. That is no longer the law. It was repealed, I believe it was this year or last year. So now that is no longer the case. You will not receive a license suspension for pleading guilty or being found guilty of a drug charge in Pennsylvania. And in the past, typically the way we dealt with that, if we could, the person was charged with a drug possession charge, and we were attempting to negotiate a plea, we would negotiate a plea to paraphernalia, which would not result in a license suspension. But that is no longer necessary. Obviously, we still want to negotiate a good deal if we have to, but the drug paraphernalia charge, going after that one as opposed to the drug charge, isn't necessary to prevent this suspension. Now, in New Jersey, it's a little different. In New Jersey, the judge can suspend your license from 6 months up to 2 years, but it's not mandatory. It's discretionary, and as long as your attorney can argue to the court that you have an extraordinary hardship, the judge, in my experience, will not suspend your driver's license. Well, are there situations? Sure. But I think that if your attorney simply tells the court that you're working, you have a supportive family, I believe most judges will understand, provided there's nothing too aggravating in the case. Like, for instance, you were found in possession of drugs with kids in the car, and in addition to the DUI potentially, DWI in New Jersey. You obviously have that, and if I was a judge, typically that might be pretty aggravating. So consider that. All right. Last question. I'm on probation. What is the difference between a technical violation and a direct violation? Well, a technical violation is the failure to abide by the terms and conditions of probation. So again, probation isn't a free ride. There are conditions such as curfews, random drug testing, reporting to your probation officer at certain times and days. Any of these could result in a technical violation. Direct violation would be a conviction or a new arrest. If you were arrested or charged with a crime, the first thing that could maybe happen, that more than likely will happen, is the probation officer will lodge a detainer against you. So if you're being held, the court may grant you bail, but the bail will not, if you're found post bail, you will still not be released because of the detainer, and you will be held until the matter is resolved. Now, your attorney can file a motion to lift the detainer, and the court may or may not consider it depending on your probation history and the nature of the new offense and the new charge. So with regards to a violation, we're only talking about typically a conviction. I would always tell you that if you're not convicted and your case is dismissed or you're found not guilty, obviously your attorney's going to want to argue your presumption of innocence, and the court should consider that. And I believe that in most situations, most judges, if they're fair, will give you that presumption, despite the fact that you're on probation. They may give you just a stern look and say, "Look, sir, this happened, and you were acquitted. The case was dismissed, but you are on probation. You are under supervision of the court. but I'm not going to violate you. I'm not going to find a violation because of this. And that's an important point that you have to consider. If you are on probation, again, it's not a free ride. So that looks like all the questions this week. I want to thank you all for listening once again. Every week we take these questions. It's my hope that by answering them, they will help you or a friend who's facing criminal charges. If you like these videos, please like and subscribe. We do these podcasts every week. If you have questions, please feel free to email me at alfonso@gambonelaw.com. Visit our website, gambonelaw.com. On there, you can also submit a question through our online forms. At the website, I have downloadable books, my blogs, access to all of my videos, really a tremendous amount of content in the area of criminal defense for Pennsylvania and New Jersey, which is where our law firm practices. So I would look forward to seeing you next week, and I wish you the best of luck with your cases.